There is a concept in law called alibi. From the Latin elsewhere, it means exactly what it sounds like. At the time the crime occurred, the defendant was somewhere else. They could not have done it because they were not there. An alibi is supposed to be the clearest possible defense. If 28 people can tell you where a person was when a crime occurred, and the crime occurred at a specific time, and that person was provably somewhere else at that time, then the person is not guilty. The logic is airtight, unless the system decides that 28 people are wrong and one person is right. In the spring of 2008, a 41-year-old high school teacher named Marcus Reed was convicted of a burglary and assault that occurred at 2:15 in the afternoon on a Tuesday in October 2007. The victim, a 67-year-old retired woman named Dorothy Wells, identified Marcus Reed from a photograph lineup as the man who had broken into her home and struck her. At 2:15 on that Tuesday afternoon, Marcus Reed was standing in front of his Year 9 history class at Whitmore Comprehensive School in Birmingham, England. He was 37 minutes into a double period that had begun at 1:38 and would end at 3:25. 28 students were present. The lesson was recorded in the school register. The register was signed by Marcus. 2 other teachers had seen him in the corridor before and after the lesson. None of this prevented his conviction. None of this prevented him spending 4 years in a British prison, teaching because he could not stop being what he was, before the investigation that should have happened before the trial finally happened after it. Marcus Reed had been a teacher for 14 years. He had taught history at Whitmore Comprehensive for 7 of those years, and had built the kind of reputation that takes time and consistency to earn. Students who were indifferent to history when they arrived in his classes sometimes left with a genuine interest in it, which is the specific alchemy that marks a teacher who is genuinely good at the work. He was 41 years old in October 2007. He lived alone in a flat in Handsworth, Birmingham, drove a 10-year-old Peugeot, spent his weekends cycling and visiting his parents in Wolverhampton. He had never been arrested. He had never been in trouble of any kind. His school performance reviews were positive and had been for all 7 years. On the afternoon of Tuesday, October 16, 2007, Marcus was teaching his Year 9 double history period. The subject was the causes of the First World War. He had prepared a series of source documents for the students to analyze. The lesson had begun on time at 1:38. The register had been called and signed at 1:42. At 2:15, while Marcus was walking between the rows of desks helping students with their source analysis, a woman named Dorothy Wells was being attacked in her home 3 miles away. Dorothy was 67 years old. She had retired from teaching herself the previous year. She had been at home when someone had broken in through her back door. She had been struck on the arm. Her jewelry box had been taken. The attacker had run. She had seen him for approximately 20 seconds. He had been black, male, she thought in his 40s, medium height. She had been frightened and in pain, and she had seen his face for 20 seconds before he ran. Dorothy Wells cooperated fully with the investigation. She gave the police everything she could, her description, her account of the attack, everything she had seen in those 20 seconds. She was a clear and careful witness. She wanted the person who had hurt her to be found. The photo lineup was conducted 10 days after the attack. It was not conducted blind. The detective present was the lead investigator who had been working the case and who had a suspect in mind. This, as we have discussed on this channel before, is a known and documented risk factor for misidentification. Dorothy looked at the 6 photographs carefully. She took her time, and then she pointed to the photograph of Marcus Reed. She said, "I think this is him. I'm not completely certain, but I think this is the man." Those words, "I think this is him. I'm not completely certain," are significant. They are not the words of absolute certainty that the justice system treats eyewitness testimony as representing. They are the words of a woman doing her honest best with an imperfect memory. The lead detective wrote in his report, "Witness identified suspect from lineup with confidence." The word confidence does not appear in Dorothy's statement. It appears in the detective's interpretation of her statement. Marcus Reed was arrested 6 days later. He was taken out of his school in the middle of the afternoon, in front of colleagues and students, which is a detail he has said, in the years since, that he has never stopped feeling. He told the arresting officers immediately, "I was teaching a class at that time. I have 28 students and a register. I have 2 colleagues who saw me. I was at school." The arresting officers noted his claim. The claim was passed to the investigation. The investigation did not visit the school before charging him. It did not interview the students. It did not examine the register. It proceeded on the identification, and the charging decision was made. Marcus Reed was charged with aggravated burglary and assault. The trial of Marcus Reed opened at Birmingham Crown Court in February 2008. It lasted 5 days. The defense was straightforward. Marcus had an alibi. The alibi was his school attendance register, the testimony of 28 students and 2 colleagues. The defense presented all of this. It was, in terms of alibi evidence, unusually strong. Not one person, not a family member, but 28 independent witnesses and documented school records. The prosecution's response was to challenge the reliability of the school records and to suggest that the register could have been signed before or after the lesson, and that the students might be mistaken about the time. They brought in a handwriting expert who testified, accurately, that the register signature was consistent with Marcus's handwriting, which proved nothing either way since he had signed it. And they had Dorothy Wells, who took the stand and said, with the honest qualification she had always maintained, that she believed the man in the photograph was the man who had come into her home. The defense asked her, "Are you certain?" She said, "I believe so. I cannot be 100% certain. I saw him for about 20 seconds and I was frightened." The prosecution asked her in re-examination, "But looking at that man," she indicated Marcus Reed, "is that the man you saw?" She said, "I believe so, yes." The jury had 28 students and a register on one side. They had a frightened 67-year-old woman who believed the man in the dock was the man who had hurt her on the other. Human beings are not good at assigning appropriate weight to statistics versus personal testimony. 28 names in a register feels abstract. A woman sitting in a witness box pointing at someone feels immediate and real and true. The jury found Marcus Reed guilty on both counts. He was sentenced to 6 years in prison. He was 41 years old. He had 28 students who had been in his classroom when the crime occurred, and none of it had been enough. Marcus Reed entered HMP Birmingham in March 2008. He was 41 years old. He had been a teacher for 14 years and had been convicted of a burglary and assault that had occurred while he was teaching. He requested, in his first week, access to the prison education department. He was assigned to assist with literacy classes for other inmates. He taught for 4 years without a classroom, without a register to sign, without the particular tools of his profession. He taught with whatever was available, donated books, printed worksheets, the specific patience of a man who had not stopped believing in the purpose of the work even when the work had not protected him. His parents visited monthly. His mother, who was 73 and had arthritis that made the journey difficult, came every single time. She sat across the visiting room barrier and talked about the neighborhood and his father's health and his sister's children, and she never once suggested that he should accept what had happened, because acceptance was not a word she recognized in that context. His 28 students, or some of them, had not forgotten. 3 of his former Year 9 students, now in 6th form or university, had contacted his solicitor independently in the months after his conviction. They had each given statements saying they had been in his class on October 16, 2007. They wanted to help. They were told the conviction had been made, and the avenue for using their statements was an appeal. The appeal was filed in 2009. It was refused. The court found that the alibi evidence had been presented at trial, and the jury had weighed it against Dorothy Wells's identification and had made their decision. The decision, the court found, was within the jury's proper function. Marcus read this judgment and then went back to his literacy class. In 2011, a man named Gary Soames was arrested in Wolverhampton for an unrelated burglary. During the processing of his case, his DNA was run through the national database. Gary Soames was 44 years old, black, medium height. He had been living in Wolverhampton since 2006. In 2007, he had been living in Handsworth, the same area of Birmingham as Marcus Reed. His DNA matched traces found in Dorothy Wells's home. Investigators, following the DNA match, reviewed the 2007 case. They found that Gary Soames had no alibi for the afternoon of October 16, 2007. They found that he matched Dorothy Wells's original description, black male, 40s, medium height, more precisely than Marcus Reed did, in ways that the original investigation had not pursued. They interviewed Dorothy Wells. She was shown Gary Soames's photograph alongside 5 others. She identified him. She said, with the same honest qualification she had always maintained, that she believed this was the man. This time, the detective's report recorded her words accurately. Gary Soames was charged with the October 2007 attack on Dorothy Wells. Confronted with the DNA evidence, he made no comment in interview. He was convicted in May 2012 and sentenced to 4 years. By that time, Marcus Reed had already served 4 years of his sentence. By that time, Marcus Reed was still in prison, because the administrative machinery of exoneration moves more slowly than the administrative machinery of conviction. Marcus Reed's conviction was referred to the Court of Appeal by the Criminal Cases Review Commission in September 2012. The CCRC had been alerted by Marcus's solicitor immediately after Gary Soames's conviction. The Court of Appeal quashed Marcus's conviction in November 2012. He had served 4 years and 8 months of his 6-year sentence. He walked out of HMP Birmingham on a November morning. His parents were there. 3 of his former students, now in their early 20s, were there, the same 3 who had given statements in 2009, who had tried to help before the system was ready to listen and had come back when it finally was. One of them, a young woman named Priya, who had been 15 when she sat in his classroom on October 16, 2007, had brought a copy of the class register from that day. She had obtained it from the school as part of the appeal process and had kept her copy. She handed it to Marcus outside the prison. She said, "I signed it. Look." He looked. Her name was there. October 16, 2007, 1:42 in the afternoon. Present. He held the register for a long time. Then he said, "Thank you for coming back." She said, "We never stopped trying." He said, "I know. I knew that inside. It helped more than you know." Dorothy Wells was told about Gary Soames's conviction and Marcus Reed's exoneration in the same conversation with her family liaison officer. She was 72 years old. She had given an identification that had sent an innocent man to prison for 4.5 years. She had done so in good faith, with the honest qualification she had maintained throughout. The system had treated her qualification as confidence and had proceeded on that basis. She issued a personal statement to Marcus Reed through her solicitor. She said she was deeply sorry. She said she had always said she was not completely certain, and she had not understood that this would not protect him. She said she hoped he could find a way forward. Marcus Reed responded through his own solicitor. He said he held no anger toward Dorothy. He said she had been a victim who had tried to help. He said the anger, to the extent he carried any, was directed at the process, at a detective who translated uncertainty into confidence, at a charging decision made without basic verification of an alibi, at a system that had allowed an identification to outweigh 28 present students and assigned register. He received compensation from the British government and filed civil claims that were settled in 2013. He returned to teaching in September 2013, not at Whitmore Comprehensive, which felt too complicated, but at a different Birmingham school, a fresh start, a new classroom. The Disclosure and Barring Service, after a review, confirmed that his exoneration meant the conviction would not appear on enhanced checks. He was permitted to teach. He is 57 years old now. He has been teaching for 30 years, of which 4.5 were spent in prison. He says the years inside did not take his love of the subject from him. He says that history, the actual study of it, the way it explains how human beings have organized and disorganized themselves across centuries, sustained him. He would read history in his cell, and in the education room, and on the walks between them, and the reading reminded him that the present moment, however wrong, was not permanent. He says, history teaches you that systems change. Slowly, badly, often only after enormous cost. But they change, and that is the only thing that makes the cost survivable. He pauses. He says, I was the cost in my own story. I hope the system learned something from paying it. Then he says, I have a class at 9. Excuse me. And he goes.